but the time is sensitive. We have to start right away because our attorneys have to get going. So again, welcome everyone. I'm very, very. Oh, you don't want to come. I'm very happy to see you all here and take out your very important day of the day to come here to join our important workshop. My name is Thomas. For those who don't know me yet, I'm a founder, Remax Advisor, and Up Capital and Mortgage. Our firm right here to help you to get wealth and preserve your wealth and protect your asset. Besides that, we want you to be secure with your investment. So the reason I hosted this event today, because for the past few months, I have several phone calls from my past clients. They calling me because they don't know how to handle the property after their spouse passes away. And also some people that my client about many years ago, they a lot of property, and they asked me, I want to transfer my property back to my children. How I do that? I told them, I'm not an attorney, I can help you with that, but I can get the connection to the right attorney to walk you through that. Because that all the matter really affect every family. That's why if you have a plan in place, it makes all difference. So in order to guide us to the right direction, I would like to introduce you attorney Isaac Maing, who specializes in estate planning, and his associate. He will share with us the valuable information inside how to protect your assets and how to make sure your significant other will be taken care. Without no further ado, I would like attorney Isaac take the floor.
Good afternoon, everyone. Thank you for having me, Thomas, here in your office and with your clients and your friends and family. My name is Isaac Maing. I'm one of the attorneys at Garcia and Sani, and all we do is estate planning. We're located in San Jose, but we can do estate planning in all 50 states. Okay. So I'm going to share with you a little bit about what estate planning is, what it's not, right, and some common misconceptions and how we can protect our families, right, moving forward. So what is an estate plan and who needs it? An estate plan, there's this common misconception that only millionaires, only gazillionaires need estate plans, but that's further from the truth. Because an estate plan protects not only the things of value that you have, but it also protects you as a person. It also protects your beneficiaries, your family members that will receive your properties later on. So what do these stars all have in common?
Lots of money, but problems.
Lots of money, problems,
Death.
and no estate plan. They all died without an estate plan. Michael Jackson, Sonny Bono, Bob Marley, Prince, right? Amy Winehouse, etc., etc. And many more. I mean, the list goes on, right? If this group represented the United States, only about maybe 2 or 3 of you in this room would have an estate plan. The stark reality is, right, only about 25%, 30% of the families in the United States have an estate plan. Here are some other examples. Kobe Bryant actually did have an estate plan. He was, one of my favorite basketball players. He died, unfortunately, in that helicopter crash, right? But he didn't update his estate plan. Shortly before he died, he had a baby girl, right? A baby girl, but the baby girl was not included in the estate plan. So the family, after he died, right, the family had to spend lots of money updating the estate plan and getting a judge's order to include that baby girl in the estate plan, right? So it's just as it is important to have an estate plan, it's also important to update it regularly to take into account major life events like a death, a birth, right? Maybe a divorce or separation, etc. Bottom left, who knows This gentleman on the bottom left.
Oh.
Tony Hsieh,
Yeah.
he was the founder of
Black Panther.
Zappos.com, right? Zappos.com. He sold his company to Amazon for, I think, $1.2 billion. But the unfortunate thing, he didn't have an estate plan. So his family had to fight so many people in court, and he lost hundreds of millions of dollars. His estate, I should say, lost hundreds of millions of dollars through that process. Right? If you don't have an estate plan, right, the government has an estate plan for you, right? It's called intestate law, right? And it's not fun. Right? It's a heavy burden on families going through that probate process. Oftentimes with money and properties, right, a lot of families fight, right, after the decedent moves on, right, passes away. So we want to prevent that from happening and, you know, maintain that family cohesiveness and harmony. Another example, Chadwick Boseman, he didn't have an estate plan, right? He's a famous actor, he passed away. His wife and his parents were fighting it out in court, right? But ultimately, at the end of the day, it was the government and the attorneys that won out, right? And then Bob Lee, right? Founder of Cash App, he unfortunately died in San Francisco, right? But here's his family's on GoFundMe raising funds for his funeral. Because through that probate process, if you die without an estate plan, your assets are frozen, right? Your assets are frozen. So if you die without an estate plan, the courts will decide who gets your assets. The courts will decide who will be the guardians of your minor children. The courts will decide who is your personal representative for your estate. The courts will decide how and when your assets are distributed. And on average in California, it costs between 8 to 11% of your asset value just by way of attorney's fees. Right? It's an expensive process. That doesn't take into consideration the court costs, administrative fees, etc. So let's say you have $1 million property, right? Just for that $1 million property to go through probate will be around $100,000. Think of it that way. Right? And then any amount of value over the estate tax threshold will get taxed, right? Up to 40%. And then it's a long process. On average in California, it takes about 24 months. Right? So in a typical estate plan, there are these 5 documents: the will, the trust, the durable power of attorney, the advanced medical directive, and the HIPAA authorization. The first 2 documents protect you, right? Mainly when you pass away. And the last 3 documents protect you when you're still alive, but you've lost capacity to make decisions. You're in a coma, you have Alzheimer's, dementia, you have brain cancer, and then the doctor confirms that you're incapacitated. In those situations, your family or your close confidants, right, will use the last 3 documents, the power of attorney, the advanced medical directive, and the HIPAA authorization to make decisions on behalf of you when you can't communicate. Right? The first 2 documents, I'll start with the trusts. Usually trusts are divided into 2 categories. Right? There's the revocable trust and the irrevocable trust. The revocable trust is mainly used by about, I would say, 90% of the families out there. Right? And the reason being, you can make as many changes as you want during your lifetime. You can change the rules of distribution, you can put in property, take away property, you can change the beneficiaries, you can even cancel the trust. Right? It's a living document. Right? Unlike the will, you don't have to die to take advantage of the trust. And there's 2 benefits. Number 1, your family will avoid the probate court system. The probate court system that I just explained, right? That's such a headache. Your family will avoid that by using the trust. The second benefit, and I'll get into the details in a little bit, right? But it's called a step-up basis in cost. Right? So, in a nutshell, what that is that your family won't have to pay as much capital gains tax. Right? when that asset is transferred to your beneficiaries. There's another kind of trust called the irrevocable trust. And irrevocable trusts are trusts that you set up the rules one time, but it's very hard to change the rules. It's not revocable. And you gotta release control to a third party trustee to manage your properties inside the irrevocable trust. There's some pros and cons, right? The con would be you have to relinquish the control over your assets. The pro, you get heightened legal protection against lawsuits, right? And the government can't put a lien of reimbursement against your properties if it was created within a certain window. Right? So if you're you foresee using Medicare benefits, long-term care benefits, then some families put their assets into an irrevocable trust so that later on the government can't put a lien of reimbursement, right, on the benefits that were paid out. Some other instances, if you have a special needs family member, you can create an irrevocable special needs trust so that the sudden inheritance by, right, the grantors doesn't affect the special needs person's benefits from the government. And sometimes, right, people create a charitable remainder trust. I'll go into that on the next slide here. A charitable remainder trust is an irrevocable trust where you assure the income stream during your lifetime, let's say from a property, right? And then after you pass away, it goes to a charity, a nonprofit, a church, cancer research, whatever have you, right? And the benefits are any assets that are in there grow tax-free. And assets are not included in the overall tax calculation, the estate tax calculation. Currently, in 2025, that threshold for a single individual is $13.99 million. For a married couple, it's $27.98 million. So some families have assets over that amount, so they will put it into the irrevocable trust so that they don't have to pay the up to 40% tax on the estate tax. Okay, here's a real life scenario, right? A gentleman came to the law firm. In May of 2021, his sister passed away. She was single mother of 5, homeowner in the Bay Area of $900,000 house, and she had a life insurance plan listing all the children as beneficiaries. About 5 months later, his mom passes away due to COVID, right? She was married at the time to the gentleman's dad. She was a homeowner together with her husband of a $1.3 million house in the Bay Area. And then she had a life insurance plan of $500,000 listing the husband as the beneficiary, right? Almost a year later, the gentleman's dad passes away. Right? He was widowed at the time. He still owned that $1.3 million house. And he had a life insurance policy about $500,000 listing the wife as the beneficiary. He didn't change that beneficiary designation. So the sister unfortunately did not have an estate plan, and the gentleman had to pay about a little over $100,000, right, to go through the probate court process. $12,000 for the guardianship of the minor children, $6,000 for all the accounts monitored by the court, and probate court was needed for that house, right? Around $90,000, right, just for the house. But if his sister had an estate plan, it would be about $300 to the county, and they would transfer that deed easily over to the gentleman. Similarly, the mom. The mom did not have an estate plan. The gentleman had to pay about $12,000, right, to transfer the assets to, right, the dad. If she had an estate plan, no dollars, right? No dollars. And the dad, right? The life insurance policy where he didn't change the beneficiary, that policy had to go through probate, right? Because there was no one to receive the funds. That was $50,000. Probate court needed again for that $1.3 million house, about $130,000. So he had to pay around $180,000 when his dad passed away. But if the dad had an estate plan, about $300 again to the county, very easy. So all in all, in a span of about a year and a half, the gentleman had to spend a little over $300,000, right, for this probate court process, etc. If they did have an estate plan, the sister, the mom, the dad, about $600 to the county, and then $2,500 to $6,000 to set up the estate plan, right, for all three people. So I talked a little bit about the step-up basis where your family does not have to pay as much capital gains tax, right? For some bathroom reading, right? It's 26 U.S. Code 1014, and basically what that says is that you don't use the original purchase price of an asset to calculate the capital gains tax. If that property is transferred by the decedent, the person that passed away, through a trust or a will, right? So here's an example. So let's say John Doe bought his home 30 years ago for $100,000. And now the home is worth $1 million, right? When the IRS looks at this, when John passes away and transfers that house to his beneficiaries, the IRS will use the $1 million valuation to start calculating the tax, not from the original $100,000 cost where he bought the property, right? So in a way, right, capital gains tax can be a heavy burden, right? It can be up to 40%. So your family will not have to pay that when the house is transferred through the trust to your beneficiaries. So imagine your beneficiaries receiving that house and selling it immediately for $1 million. For that transaction, there is no capital gains tax according to this rule. Right? Also, it applies to stocks and cryptocurrency, right? Let's say you bought Apple stocks 30 years ago for, I don't know, $5,000. And when you transfer those stocks to your beneficiaries, let's say it was worth, I don't know, now $500,000. Your beneficiaries will not have to pay capital gains tax on that transfer. The IRS will use what the value of the fair market value was of the stocks at the time the decedent passed away, right? And then from that point on, they'll calculate the capital gains tax. It's a huge way to preserve value in stocks, in real estate, other types of assets, and create generational wealth for your family. So imagine your beneficiary setting up another trust and transferring the same assets to the next generation. So in theory, right, the capital gains tax, right, gets recalculated. The new basis gets stepped up through multiple generations, right? So it's a great tool, right? Great tool. Okay, so I'll leave you with this thought, right? A lot of times we buy assets, right? We buy things. We work so hard to buy the house, the vehicles, put money in the bank account, but a lot of times we don't think about protecting them, right? And one way to legally, on the legal side, to protect it is through estate planning. Estate planning is a process, right? And we work with financial advisors and realtors to make sure that these things are protected, right? Not just through legal documents, but insurance policies, right? Other transactional guarantees, right? And we can work together to create a holistic plan for your family and see how best we can save money, especially taxes, right? There's two things for sure, right? Death and taxes, right? How do we minimize the taxes legally? That would be the way through estate planning and through different vehicles out there that we can discuss. We do offer a free 30-minute complimentary consultation. Please talk to the person that invited you, right? And they can help set up that in-person consultation or through Zoom, right, at the law firm. So I'll stop there. I'll open it up to any questions and answers. Yes, ma'am.
Yeah, go ahead.
Oh yeah, so hi, my name is Victoria. Get to work with attorney Isaac and also Thomas here. But yes, we encourage questions. Actually, through the question, you will learn the different scenarios and will learn a whole lot more. Anybody? Yeah. Anybody has questions?
question.
Sure, yeah, there you go. Okay, we'll have this gentleman. Sorry, what's your name?
Charlie Wambeck.
Okay, hi, yes.
Yes, we saw an attorney, an accountant, and he said to put our house in a joint tenancy with rights of survivorship. So if you have rights of survivorship, does that mean you would have the basis would remain the same, or would that be stepped up too?
So if you hold the property as, so I'm gonna repeat the question, right?
Yeah.
So you hold the property, you have the house, on the deed, you own it under JTROS, the joint tenancy with right of survivorship.
Right.
So if one spouse passes away, the deed transfers to the surviving spouse. Right? It doesn't go through probate in that situation.
But the
Right?
basis stays the same.
The basis, yeah, the basis still stays the same.
So if you had a trust, the basis would be stepped up.
It'll be stepped up, correct. So that's why we highly recommend a trust, right, for that step-up basis. We don't recommend the will, even though the will does give you that step-up basis, we don't recommend it, right, on a standalone will, because all wills in California have to be probated, right? So we combine it together with the trust, so that your family doesn't have to go through that process. Because the probate process is a very public process. Everyone gets to see what your family has, who gets what, etc. I forgot to make a disclaimer, guys. What I'm sharing with you guys today, I gotta say, it's not formal legal advice, right? But I'm just sharing the information. But if you guys want more formal legal advice, then I can tailor that advice based on your family situation. So I'm just giving you some general information for general knowledge. Yeah.
Any other question from the audience?
I have a question. If I'm not married, my parents passed away already.
Sorry.
I don't have any children or adoption as children. If suddenly I pass away, I don't have the trust to make it. What going to do with my house for the government? They will take over my house or
Well, yeah. If you die without an estate plan, right, it defaults to, right, intestate law. So the courts will determine how to distribute your property.
it takes how long?
It will take how long?
Yeah,
It takes a long time in California. It takes about, on average, 2 years.
3,
2
On average, 2 years
2 years.
2 years.
Okay.
in California. On average.
Then
But-
how much?
Yeah, no. But if I have some relative, not the direct relative, maybe my cousin or something like that. They live outside the USA. They know I passed away. They can come to US to claim the property or not.
Possibly, right? They would have to file an action in court, right?
And then
To they claim, and then the judge would have to determine if that's a fair distribution.
how they prove they are my relative?
That's why you make a trust.
That's why you don't wanna be in that situation, right?
Yeah.
That's one of the benefits of having an estate plan, is you clearly communicate your intent.
So wait, I wanted to ask, so let's just say he doesn't have anybody here, but he established the living trust, but he named someone, let's say you name someone, I think that's also what he wants to say.
Yeah.
Name someone in China, let's say, right, to inherit this property, is that possible through the living trust?
Yeah, that is very much possible. The beneficiary does not have to be a US citizen
Okay.
or a resident, right?
He need to pay the tax. I mean the tax not
Tax is unfortunately unavoidable. He would have to report it, right, and pay taxes in the country where he resides.
Oh,
Or not in US.
If he's not a US citizen, then he doesn't have to pay US taxes.
Oh, okay.
any tax,
I'm sorry.
any tax. You don't need to pay any tax in US.
If he's not a US citizen, no, right? You would have to pay taxes in
In
the
your-
country where he
Oh,
resides.
okay.
Oh.
I think it's opposite.
again, show in that note, we did make sure again, it's an education, workshop. You know, we're not a certified tax attorney, international tax attorney, with general information guideline and idea for you to go, okay? So, and also, when you have further question, attorney give you 30
Yeah.
minutes free consultation because you come here today. So you have to make sure you get his business card, have that conversation, sometimes privately. You don't want everyone to hear about your situation, okay? So
Yeah.
next question, please.
Just a quick question, kind of add on, like, again, this is just theoretical, right? We're just talking
Yes.
scenarios, so no advice or anything, but just general kind of idea. So let's say an individual, like in that situation, wanted to sell the home, right? To avoid that situation happening, to be able to, enjoy the benefits of through the labor,
Sure,
right? So,
yeah.
so let's say they sold it through a realtor, a local realtor, and then, those proceeds were transferred into a deferred sales trust, and they invested, bonds, stock, things that are gonna generate income for that person to live off of in retirement.
Sure.
From my understanding, is that a method to be able to, forego, or not forego, to, defer taxes, capital gains tax?
Yeah, so great question, right? So the first sales trust, guys, is basically an installment sale agreement, right? Where you don't get the proceeds of the sale of any estate asset all at one time, but rather it's broken down into installments. But you still have to pay taxes on those installments, right? So it is a great way to defer those taxes and not pay the taxes all at one time, right? It's actually, so in some states, it's observed, right? In some states, they don't use deferred sales trust, right?
In
ESQs.
California, is it used?
In California, it is, so, it is used, yeah.
Next question?
Question. We set up our living trust with an attorney, and we don't have, contact with the attorney anymore. How do you go about updating our trust or adding,
Yeah, so your attorney, just because you went through that law firm or attorney, right, doesn't mean that you have to keep on using that attorney or that law firm. You can go to any estate planning law firm, they'll review what you have
okay.
and see what changes you wanna make, and then they'll give you a price, right, for those
Okay,
services.
so you mean the physical living trust?
Yeah, it's a physical living trust, right? What I recommend is if you have it in paper format, just scan it and have a digital copy as well. And then you can, usually what you do is you just email it to whatever law firm, right? Like our law firm, we do complimentary review, so we can definitely review it for you.
So we need to add a property and a child to the trust. How easy is the process, or how long is the process?
Yeah, it takes usually about 3 to 4 weeks at most. We have to review what was done before, right? Make sure everything's compliant with the rules inside your trust. And then there's 2 types of changes, right, for revocable trust. There's a amendment that you can do, or you can do a restatement. A restatement is a complete revamp of everything, right? Imagine just getting like a new trust altogether, right? But we still use the old date that you established the trust. Now, the other kind is an amendment, minor changes, like changing the name, adding more property, right? That's called an amendment, and that's pretty easy to do.
And if we have a new trust, how often do you think we should update our trust?
I recommend my clients to review it every year and every major life event.
Thank you.
Of course, yes.
Yes, I have 2 questions. In terms of making an amendment, let's say I buy another property, I established the living trust already. Can I just go down to the county and change the deed name to the current living trust name? But not necessarily have to add to the living trust? Is that
Yeah.
feasible or no? And then the other question is, when you say we have to pay 40%, right? Sometimes we just buy the house and we owe, let's say, house 1.5 million, and we owe 1.2. So the equity is actually only about 300,000. The rest of them are loan. So that 40% on the value of the house doesn't matter, or or the equity of the house?
Right. So the first question, right?
Yeah.
Well, I'll start with the second question.
Okay.
The second question, right? So they take the fair market value at the time of the grantor's passing, right?
Ah,
Regardless of whatever liens are on there,
ah,
right? So it can be sizable. It can be
okay.
sizable. So that's why we definitely recommend transferring assets through the trust
Okay.
to avoid all that, right? The first question, yes, you can. You can revise the deed by itself into the legal name of the trust and just record it with the county. And then you can update the exhibits page of the trust,
Uh-huh.
right? And you can just, some families like to use the services of a law firm, but some families, they just write it in, sign and notarize it, and that's
Yeah.
it.
Okay.
So, it is doable.
Okay, because there's a pour over, right? Is it the pour over will inside where that can be protected?
So let's say you forgot to put an asset, like a house, into your trust.
Yeah.
Then that's why we use the will, to assure everything is included in the trust, right?
Okay.
So that's called a pour over provision.
I see. Thank you.
So now is my turn. It's not my question that I'm gonna ask for the people that have been asking me, but I'm not estate planning. That's why I set up this workshop today for them, but unfortunately they cannot come because the family matter. Scenario number one, I was managed the property for that gentleman more than 9 years, and he passed away since COVID. But I continued to manage the property, and I asked, I was asked because the spouse left over would have the trust, but never been recorded.
Hmm.
And she could continue to collect the rent until one day they have an argument, and then they go to the city, and the city is where the seller. And that time she called me back and said, hey, what should I do? I say, you need to catch an attorney. So because you have a trust, you never recorded. Now you have a problem because the deceased person cannot speak on your behalf. How the check will cancel? But one of the property, and it's not managed, I only manage the commercial one. The residential side that on his name, but before he passes away, a couple of months that he made us quick, but never recorded. And he asked me advice, said, looking for you. That what she might be watching right now from at her store. So probably you can refer very short answer to her what her situation look like. That's the first question.
Yeah, so in California and actually most states, there's no requirement that the trust be recorded.
Okay.
Yeah. So as long as you sign and notarize the trust, it's legally valid, right? What you want to record is when you fund things, right? When you put things into the trust. So that's why we changed the deed into the name of the trust of a house or a property, and we record it with the county. Same with sometimes if the properties are in an LLC or corporation, right? We do an assignment agreement where you transfer the interest to your family trust. And some families, right, they actually record that assignment agreement, right? In that situation, right, we would have to go over the actual trust language and see what kind of provisions there are. And hopefully, in addition to the trust, there was a power of attorney, right, that was executed. Then she can make decisions on behalf, or as a sole trustee left in the trust, can act on behalf of the best interest of the trust, the beneficiaries, etc.
So do the trust have to be recorded in order for her to manage the property or continue to get when a right coming out, say, collecting the check if under her husband passed away already, or no?
Yeah, the trust does not have to be recorded.
Oh, okay.
I guess the question also, what I'm understanding is, the trust has been established, but it doesn't mean that your property is funded, meaning that the title of that house is
It's
still
still
the
under his.
husband's name, right? So
Correct.
it's not John and Mary Living Trust, Family
No.
Living Trust, so that's
Oh.
why. So that's number one. But number two, what he made a point is that when John, the husband, established that living trust, he did mention the power of attorney name, which is whoever that person is.
Yeah.
That person maybe can, on behalf representing John, to speak.
So usually a
Right.
power of attorney, right?
I
Thank you for that, point. The power of attorney, right, usually dies with the person that gave the power.
The power.
Yeah. So when her husband passed away, right, she can't make any more decisions on behalf of him unless it's put into a trust, right? But if the deed is not in the name of the trust, they never put the property into the trust, that house unfortunately has to be probated.
Okay, so probably he, she will listen and then probably,
Yeah.
might be, I did not go to that party yet because I don't have a legal obligation. And the second question, one of the client asked me, they bought several properties from me before. Now they are near retirement. Probably in the next few years, they own 3 property. And then they're not gonna trust, they want to give to the children, and they're probably thinking about transfer their property into their 2 of their children, so they don't have any, property, so they can get their government benefits, such as, Prop A and B. And they asked me advice, I say, no, again, I'm not an attorney and tax, so you might want to seek to advise the estate planner how you want to do that. You don't want to be, go broke, or maybe you got kicked out by your kids, you're probably doing something. But the one thing that I know that they want to transfer their property into, but they don't know how they're gonna do that. They want to say, simply want to add their children into the property, say, no, that's not the right way. You're gonna be a lot of tax consequence. The step up, tax consequence. I can answer that question, but again, I refer you to talk to the CPA to get a clarification and have an expect plan in place right now.
Yeah, that's a very good point, Thomas. That's a common misstep by a lot of families. They just add their family members to the deed. But when that happens, you lose the step-up basis, right? And a lot of times what we have to do is we gotta do a revision deed to take that person off the deed so that they can put it back into the trust. It's not 100% guaranteed that the county will approve it. We just have to make an argument that there was a mistake, an error, back when they added the person to the deed. But we can change that and revert it back to how it originally was, and then after, put it into the trust.
Yeah, and the last question would have client of mine too, husband and wife legal. The husband on the title, the wife never been a title. The husband passed away a couple of months ago too. And she asked me, and then again, I said, you have to go to see the attorney to have to transfer the title. Oh, she said, oh, in California, does it mean the husband owns something, I inherit 100% of his estate? I say,
Yeah, so we gotta really review the deed, first of all, on that. If it was joint tenancy with right of survivorship, then yes, right? That property does not have to be probated, right?
okay, so the last very general question, okay, go ahead, Charlie.
What happens if you don't know where the trust is, and you don't, and it probably wasn't recorded, you don't even know who wrote it? Does it just disappear?
Yeah, that's a problem, right? That's a problem, because if no one knows, then
Then it doesn't exist.
it doesn't exist, right? So our advice to clients, once they finish the notary process, is to keep a digital copy and email it to at least the successor trustees.
This has been 15 years ago,
Yeah, then in those cases, we've seen hard copy binders, right? And make a copy,
But
put
they
it
don't know where
into,
the copy is.
yeah, then really, there's really no help in that
Then
situation,
it probably doesn't exist.
right?
Okay.
Isaac, in that situation, does the law firm, even though it's 15 years ago, and of course if they're still there, do they have somewhat of bookkeeping or track of what the,
Most law firms will have a record,
yeah,
but then after 4 years, they usually just,
oh, they have the right to,
they can destroy the records.
spread,
She
oh,
doesn't
they
even
can
know who wrote
destroy.
it anymore.
Oh, okay,
Yeah.
just in case you remember who, but you don't know
She
which.
doesn't know who wrote it.
I see, okay.
So maybe I have the very last question for maybe all
Yes,
the
Thomas.
audience that listen right now and watching this event. Come to the end, like, I want to do the, estate planning today, what is the cost? What is start out cost? Like with one single property, husband and wife, and what the start out cost, you know, and then how often, maybe the question been asked earlier, how I should update the trust if there's no major event change, like have a new kid, have a new house, have a new like winning a lottery. So can you address it a little bit so we have an idea so they can you know prepare monetary wise?
So yeah, so here at Garcia Sani, our basic entry level kind of bare bones estate plan start at 1,300. Yeah, and if people are on a fixed income like Social Security or they're retired, we have a payment plan of $59 a month
Okay.
for 24 months.
So the basic without real estate.
Basic with real estate.
With real
We'll
estate.
revise the deed. The thing that we won't do, we won't record it with the county. So the clients have to do a little bit of work, but they get a reduced price because of that.
But that also means that they have to print out their document, is that what you're saying?
Right, they have to print out their documents, they have to record their own deed, they have to review the draft documents on their own, right? But the attorneys will draft the documents for them.
But what if they rely on 100%, you know, we don't want to do like hand-free.
Yeah.
So let's rely the law office to do
Yeah,
everything.
if they want more of a full service approach and they're like, okay, you guys take care of everything, then those start at 3,000.
3,000. For how many property, how many lot insurance?
One primary.
One primary of non-investment property, not this.
Yeah, investment properties, additional deed work that we have to do, there'll be extra costs.
Probably additional
much,
property,
yeah.
how much on the
But
average?
so about $250. Yeah.
Okay, that's all I have for today. Any other question?
Yes, where is your office and any contact number, phone number or email that
Yeah, what I
anybody-
recommend is, okay, our office is located in San Jose
Mhm.
and soon in Texas, right, and Florida. We can do in-person consultations in the San Jose office, or a lot of people do it by Zoom now, right?
Oh.
It's very convenient. If you want to make an appointment, right, I highly suggest talking to Thomas or Victoria, right, and making that, they'll help you with that appointment, right? So we know exactly where the client came from, right? And give credit where it's due.
The first option you had, the $1,300, you still send a notary to the house to sign?
Yes, in all of our plans, we send the notary to notarize. And the
Okay.
notary cost is included in that price.
Okay. I guess you forgot to answer his other question, how often do they
Oh.
need to update, or in what situation should they update or amend?
Yeah, so, major life events, right? And every year, just do a review of your documents, make sure everything's up to date. Major life events such as a death in the family or a birth, right? Moving to a different state maybe, retiring, like if there's a divorce or a separation, right? Those kind of events.
No, I'm still learning. So I guess because you gave some scenario, so let's just say you have any major whether death or birth, right? You don't update, then that person is not included. But let's say you have a lottery and you buy another house and you let's say you forget to update that, then the pour over will cover that in case, my understanding, okay? The pour over will help solve that problem in case I die. But if I don't put my kids, or now I'm divorced, I leave my husband out, or I get married, if they're not in the living trust, that can be a big problem, right? A bigger problem.
Yes.
Okay, that's what I want. So then you play it by the situation of how, but if you forget to include 100,000 you want from somewhere, oops, but that should be okay because the pour over will can handle that.
Yes, the
Okay.
executor in the will, which
Yeah.
is kind of like a trustee or
Okay.
trust,
So a person,
will have that pour over power to
uh,
put stuff outside the trust into the trust for you even after you die.
except for the person.
Except for, well,
Okay.
sometimes, right, some grantors give the power to designate new trustees or new
Yeah,
beneficiaries.
that too. Or you change your mind that your brother-in-law is not gonna handle your living trust no more. You want someone else, then you have to amend that, right?
Absolutely.
Or change that.
Yes, ma'am.
Question, I have a trust like more than 10 years ago and it's lost. Now I make a new trust with different attorney office. So is the previous trust still valid or invalid?
So it depends, right? Most likely it's still valid, but it's restated by the new trust, right? So the new trust will control over the old trust.
Oh, okay. Thank you.
So any other question from the audience, or that will be that's it, that we conclude our own presentation. If you like it, just click on like and more comments. If you like more education seminar or workshop like this, we deep dive in every angle of the check planning. In every other month, we probably can do more to see how people respond. Unfortunately, someone cannot be here, but they're a key person. But I hope they are listening or watching you right now. You might be getting the phone call. But again, thank you very much, Isaac, for coming to spend the time all the way from the South Bay and Victoria, from from the South Bay to come here to do this event. We hope we can do more often, probably once a month, with a different topic about how to protect your assets. Okay, everyone.
Thank you, everyone.
Thank
Thank you.
you.
Yeah, I wish to have.
I leave the business card to the attorney right here. You